So $2 million SkyTrain scandal, Prof.Ameyaw, Akumfi, and one suspect. Abusuya, yɛde no ho nsɛm ɛbrɛ mo akyɛ court case no na ɛyɛ nsɛm bebree na nsɛm bebree no ɛnɛ ɔmo kokopie mu ɛwɔ court $2 million SkyTrain scandal. Prof.Ameyaw Akumfi ɛna no ada court no ɛka kyerɛ ɛyɛ the accused person ne ne lawyer sɛ ɔmo nkɔ file ɛyɛ ɔmo submission of no case na ɔmo fambra na ɛnɛ Prof.Ameyaw Akumfi ene ne lawyer se kokopie mu e court. Omo kokopie mu court no ehwe eye omo submissions no court no dismiss submission na omo che say court no judges na che say they have case to answer, but omo de omo submission no ko no omo so che say omo no case ne de omo ni bibia $2 million no ska no omo form sankan accuse accuse omo nyina no enye no kra nti court ne hwe na on akweti omo sanso ye the end discharge omo cause case no omo ni ho hwe but we de ene court na kire se case no omo ni ho bibi omo mbra na omo mbra mbeyi ensem bia no emfanfa ho na court ne ka asem ne Prof.Ameyaw Akumfi as old boy na omo ka kire na baby papa no baby and pressure ekoye no na enye asam keto akra nti no latest update on $2 million SkyTrain scandal Ghana ye pesika bebre e di ayeye neoma kese the lies of your hospital near the nti no Prof.Ameyaw Akumfi $2 million SkyTrain scandal de obepu sika no e di abanti right now no and I project at the 2 year screen no enchen at the amamano SkyTrain scandal. High Court dismisses submission of no case of GIF board chairman Prof.Ameyaw Akumfi and ex-GIF CEO Solomon Asamoah. Others accused to open their defense. Abusuya inti asem no ene da ho no enye se bia ye fra mani anase bibisa eno na ya project at the 2 year screen no enchen at the amamana corruption cases no so no ebi koso the lies of Tokonu, the lies of Oforiata, the lies of Chema Wontumi abejafo ede nsem bebre to adwa ede faso e political highway ni so a ebe pese be makwa akuti ensema cause na answer na be kono Ghana ha se open computer papa and a laptop papa na we use aboria periodic computers and accessories ho na obenya laptop papa na ehse we use the location enye rakwai o Kumase Buokrom Estate Eli peke number ya egu screening chain 0247030108 and ase 0597942133 periodic computers and accessories and I'll be your laptop papa na we use mommy and bone ensem.
I'm expecting it to be a blockbuster.
The ECOWAS court's position as per the reliefs that the former Chief Justice sought from the courts, and then also what's going to be happening on July 2. Counsel, quickly.
Okay. So once again, I want to say this. You see, in the 1960s, something happened with the trial of Tawi Adamafiu and co. Yeah. And after that decision, the president of the republic was not happy because these were persons that were considered to be involved in a coup d'etat against him. So after the acquittal and discharge, the report indicates that the president was not happy. And that eventually led to the removal of the Chief Justice then. And so fast forward 1979 Constitution. A provision was put in the Constitution to ensure that justices of the Superior Court will not be removed in the conduct of their work. It is to provide that security of tenure when they act. That provision was repeated in the 1992 Constitution, the basis of Article 146, the security of tenure provisions. And it is clear, a judge in the performance of his core duties cannot be removed. So if today a decision comes and the president is not happy, the president cannot say on the basis of this, I am doing this action. No. And so Article 146 then introduced the grounds on the basis on which a justice of the Superior Court can be removed. In the specific case, yes.
If the president...
Yes.
I should go for it?
Yeah, go to number 1.
Okay, I'll pull that up.
146. And so you notice, and because you see, this is a serious platform. And by way of public education, we need to carry our people along by way of public education. So it is because of our checkered history, we introduce this particular constitutional provision. And let me say this. Attempts at removing a justice or a chief justice or whatsoever is not a recent happening. In fact, the record will show that Chief Justice Apalu, when he was a high court judge, okay, Chief Justice Apalu, when he was a high court judge, was a member of the Commission of Inquiry that investigated Nkrumah's appointees. And banned, eventually the CPP was banned. So the idea was that when the CPP element came back under Liman, there was an attempt to pay back, to get him into parliament when the new Supreme Court was created, by saying that, well, if you were the head of the judiciary at that time, come back to parliament for your, so that the CPP elements who are now part of Liman will use that platform to say we disapprove of you in parliament. A young lecturer at KNUST, Dr. Amwaku approached the Supreme Court, through which today the locus classicus Tufo and Attorney General was established. Look, the Ghana Bar Association also attempted to remove Chief Justice Aban. But when they realized that they could not get a prima facie through Article 146, they couched the same grounds as relief for the Supreme Court. The Supreme Court, through Pegan, Ajoye, and Co., cleverly saw that this was a removal attempt couched to look as a constitutional, interpretation matter. So quickly have it dismissed. Again, there was an attempt to remove Aqua by the respected Bright Akwete that founded Ajay. And so the point ought to be made very clear that from 1979, there had always been one attempt no, but I am just talking about how those attempts had been judicially, stopped or one way or the other. So that's basically it. You see, this morning...
But in those moments, announcements were not made on political platforms.
Can I proceed?
You may.
So one thing that is clear and without ambiguity is that for the removal of Chief Justice Tokono, she was not, the recommendation for her removal was not because of a judicial pronouncement. That is what the law forbids. That is what the Constitution does not allow. On this platform, nobody has put out there that Chief Justice Tokono was removed because he made a judgment against somebody or the other. Nobody whatsoever.
But if you made an impeachment pronouncement on a political platform.
Please.
You see, I listened to you, and at a point, I don't know what you were talking about, but I knew I'll have my time. What is also not in doubt is that if you look at the initial conversation of this whole process, if you recall, when Vincent Assefuah first went to the court, his accusation or prayer at that time was that her ladyship, the Chief Justice, had not been given a copy of the petition. Not long, the Chief Justice herself, then now removed, wrote to the president requesting for copies of the petition. And if you look at the ECOWAS court decision, they addressed that. That as at the time, the prima facie determination was made, she had a copy of the petition. In fact, she wanted a few days. The president graciously gave even more days so she could prepare adequately her defense. So that also not in doubt. Two, the argument has also been made that her ladyship, the Chief Justice, was denied the opportunity to put out her case. That the ECOWAS court also found to be inaccurate. The other contention that was made was that, listen, the determination of a prima facie and her suspension is may and not mandatory. And though, to the extent that there was a may in that Article 146, the President or the Council of State in exercising that power ought to have come out with a CI, because Article 296 provides where discretionary power is given to a person other than the judge, that exercise of discretionary power must be construed within the confines of a constitutional instrument. What is not in doubt is that, if you recall, in the case of Elikplim Agbamava versus the Attorney General, the pardoning of the Muntie Three, that was the contention. That by reason of Article 72 on pardoning, you needed, that was the contention Elikplim made in that case, that because the president may remit or pardon, he needed to have come out with a CI. The Supreme Court, speaking through Justice Bennett, had this to say, that to the extent that that May decision is done in consultation with or in accordance with or on the advice of, the requirement of a CI is not needed. So that has also been properly addressed by our Supreme Court. And so if you look, of all the issues that were raised point by point have been adequately judiciously addressed. So what really is the point? You see, this morning, I've heard and I've listened to my brother said, oh, in future, a president would conduct or do this or do that. You see, all this talk or new thing, for me, the lesson to all public servants is that when public service is entrusted in your care, remember their rules of engagement and deal within those rules. The view has been expressed today that previous Chief Justices had conducted themselves in a particular manner. And so that conduct has crystallized into a lawful conduct.
It was a convention established because of a policy in place.
Nobody said that.
Exactly. So
Nobody said
exactly my point. I deliberately couched it for your reverse, answer. Because I knew that would be your answer. Because we know
he's trying to be the chief propagandist.
We know by law, there's no way an illegal conduct or unlawful conduct can crystallize into legality. There's no way, even if it's repeated. In fact, if you recall, when the coalition of civil society sued the Attorney General in respect of Domelevo's removal, the argument the Attorney General at that time did was that President Mills, of blessed memory, wrote to the then Auditor General Duajima also on the accumulated leave. And for that matter, Akufo-Addo doing same was lawful. The Supreme Court said no. To the extent that that conduct, there is no way precedents can be found on it, even if it's repeated 100 times. Again, so far, Judge Nawood in the ex parte Richard Anani decision also repeated the same thing. So there is enough constitutional basis for this, you understand. But you see, this morning, I've seen that Mrekuduka went back, forth. First, he started with Fifi Kwete. Then he came to Sami Jemfi. And then it's all over the place. You see, let's not do this to ourselves.
I thought you didn't understand what I said.
Unless, of course, we are saying Sami Jemfi anticipated, or Fifi Kwete anticipated, or Eduji anticipated that the Chief Justice was going to travel with a daughter and husband. Clairvoyance.
Excellent.
Clairvoyance. No, you are basically telling me that Samuel Jemfi or Honorable Fifi Kwete anticipated that now removed Chief Justice was going to travel with the daughter or was going to travel with the husband, contrary to a policy. But you see, you remember the Chief Justice. There was a time, public conversation about pronouncement of the court When she had the opportunity to address the public, you know what she told us? He said the law is the law. And repeated it again. That the law is the law. Why are we making excuses? Why are we making excuses this morning? Look, me, the office I hold, it's a public office governed by rules of engagement. It tells you to be mindful. I recall vividly the removal of Charlotte Osei. When the issue came up that she was going to be removed on the basis of procurement breaches, some of us said, The framers of the Public Procurement Act anticipated criminal consequences when there are breaches. However, they first said when there is a breach, that breach should first be what? The Public Procurement Authority should be informed of that breach. They will set up a committee. The committee will investigate. Upon that establishment, the PPA can take a decision, one, to abrogate the contract, ratify the contract, or even do what they call rectification. That then the criminal consequences follows. When this issue came, we said, a person holding that constitutional office of electoral commissioner, if the misconduct or the misdeed flows directly from her conduct as an electoral commissioner, then you can find a basis for her removal. At that time, Mrekuduka and Co, in justifying President Akufo-Addo's decision to remove her, told us that who the hell is Charlotte Osei?
Was it President Akufo-Addo's decision?
Please. This morning,
workers
you see,
of Electoral Commission raised
Daniel Ofori is a card-bearing member of NDC. Please, do you know what is happening?
No, why are you
Who
saying
is
that
the
was
petitioner?
Akufo-Addo's
The
decision?
petitioner for the removal.
Did Akufo-Addo petition?
Okay.
No, did Akufo-Addo
But this
petition?
morning you were mentioning
No, since when the matter
I knew I'll get you. This morning you were mentioning Fifi Kwete and Samuel J.
But was Akufo, did Akufo-Addo in any way petition?
Who removed her?
The law. You mentioned the law.
So who removed Gertrude?
Gertrude because Sami Jemfi mentioned impeachment of Gertrude.
The devil is not your friend this morning.
Because he mentioned
Even
it.
the devil is honorable
He
this
predicted
morning.
it.
Even the devil
He said
is honorable.
that was what they
this
were
morning.
going to do when he had power. Akufo-Addo never petitioned anybody. So why are you mentioning Akufo-Addo?
So let the point be made clear. Any attempt by any group of persons to insinuate that her ladyship, Gertrude Tokonu, was hounded out of office, is not born out of the facts or the records.
Okay.
Look, I recall vividly, and myself and Malene Senior, on this same platform, we discussed this adequately. What was the issue then? In the midst of the hearing, I am aware of emissaries.
You see?
Emissaries, prominent people in this republic who approach the president and say, look, Mr. President, the woman says, or whatever, will resign. So she will be entitled to a benefit among other things. Even when the law says once an impeachment proceeding commences, you cannot resign because then you overreach the process. The president was willing to oblige. This should tell you this is a president who has no interest whatsoever in the proceedings.
So the president was willing to flout the law? Is that what you are saying?
To even allow, for a greater good, to allow her.
Yes.
That is how magnanimous, merciful John Mahama.
Yes.
Akufo-Addo could not exercise that judgment.
It's up to you.
The person you used to worship, Nana Dodonko, could never exercise that judgment.
Your own
Let me round
party
up.
had mentioned that you are going to impeach the Chief Justice.
Please.
And you are here, magnanimity.
You see, you talk about. You see, I do not want to go back so that I dignify what you are doing with equalization. Yeah. Why were we not in this country about Charlotte Osei and the rest?
She didn't even get a copy of the petition.
Yes.
Who was please?
And you know the person who established a prima facie against Charlotte Osei, Sophia Akufu. I don't want to talk about her. I have great respect. Please, I beg you. I have great respect. She alone, please,
your friend has been
please, she alone made a determination of prima facie against Charlotte Osei. Today she has a problem.
But not Akumfi.
Oh, okay. Please. Why are you doing
there was specific.
I'm just asking a question.
Case, so
you see,
the humble
the point, very well. The point I'm making is that she, Sofa Akufo, alone, as a Chief Justice, made a prima facie determination against Charlotte Osei, and it was lawful. Today, her colleagues, members of Council of State, makes a determination, and she isolates herself and say the decision of the collective. I mean, what's the principle here, madam? Because of the great respect I have for her, I decided that this matter, I won't even respond. But she alone. And it's on the basis of a prima facie determination that President Addo, Dakwe Akufo-Addo, together set up the Justice Burning Committee, together with Mafosa, Agnes Doji, and the two civilians that made the recommendation for the removal of Charlotte Osei. If her decision is proper,
principle of equalization,
why is she trying to undermine the decision of the collective?
Okay.
The point ought to be made adequately clear. We are building a constitutional democracy.
Excellent.
These things will be coming up. Okay. I am happy that all these lawsuits, ECOWAS courts and others are coming in. They serve a proper precedent. But let nobody, absolutely nobody, say President Mahama had or made any comment prior to becoming president about the removal of Chief Justice. If anybody is able to show me evidence of President Mahama ever making any comment as to the removal of a Chief Justice, I want the person to put it forward. Don't go and refer to very inconsequential, immaterial issues at the basis. In any case, did anybody know, with respect, that she was going to travel with her spouse or family members?
Now, it's some 7 minutes of the hour, 10 a.m. There's a question from Dr. Kwame Asante to Lawyer Kofi Bento. Says, I want to find out, okay, says, good morning to you and the panel. I want to find out, first of all, if the specific convention or policy that was adopted by the Judicial Council, which legitimizes the decisions taken by past and the specific Chief Justice in question, is, if proven to be inconsistent with the Constitution, one that can be glossed over as a mere administrative situation.
No, even the policies you are found to have breached, even the policy. There are two different things. The policy itself, in and of itself, was not declared unconstitutional. But even the same policy that others had used previously, she was found to have breached it.
I see.
So it's a two different things.
The answer to Dr. Sante is yes. One, there was a convention, something they did. Lawful, unlawful, that's another matter. But they did that. They interpreted the rule apparently differently. Now, in the particular case, what I am told, or what I read, is that she also did what is normally done. And an audit question was raised on it. Why this? And it was answered. So, in other words, it was approved for her to do it. She didn't approve those things. She went ahead and did the expenditure. Her internal auditors and accountants, etc., passed it. Auditor General raised questions on it. It was answered. And in the final audit report coming out of the Auditor General's office, it was passed. So, all the things that are being said about it being illegal or whatever it is, clearly the woman did not get up and do something which was not done. And it was passed ultimately in that audit report. Now, the point that is being made is, even accepting that it was not lawful, it does not rise. It's an administrative lapse to the point of the removal of a Chief Justice in the contemplation of the law as it is. Okay, so the short answer is yes. But this is the long answer.
Just on this particular point about the threshold and whether or not it arises.
You see,
and then I'll come
when you open
Mesano,
Article 146, it doesn't put threshold, it just says misconduct. So if you breach a rule, it means that, strictly speaking, any rule you breach is a misconduct.
Right.
If you park in the wrong place.
Yes, it's a
We should remove
misconduct.
you as a chief justice.
Of course.
Okay.
You see,
course.
you see, when Charlotte was removed, Mr. Abdullah Malik Kwekubako went to the Supreme Court with his lawyer Samson Ladi Ayenene, and I was in court that day. His argument was that the specific allegations against Madame Charlotte Osei had nothing to do with her conduct, and that there were procurement infractions. I was in court that day. The justices of the Supreme Court asked the lawyer in open court, is it your suggestion that evidence of a breach of statute is not a misconduct to warrant such a removal? And that's how the matter ended. I was in court that day.
I see.
So it is either we come up with a clear legislation detailing
do so.
the specific conduct that can crystallize into that removal process, or we leave it at that.
Is it your contention that
mindful that we're in this country when justices, Superior Court justices were removed on Anas Aremiyaw's what shall I say, exposés,
number 12,
and all the matter that have come. So you see, if we say that the list is exhaustive, it becomes problematic.
So I was asking, is it your contention that every infraction whatsoever is sufficient ground to remove a chief justice?
That question doesn't arise here.
Let me ask.
When we have millions of citizens,
let him allow me to ask. Let me allow
so that you respond.
Asking the question.
Okay, abusua we ne ensema ekoso e political highway so Professor Ameyaw Akumfi ne honsem na ye de brema enye asem keto akra bedamase samoje pene kokuti sa ensem we edemai aha gossip politics TV so